Yes. Yes. Hmm? 58. Ah. So you want an adjournment? Okay. Okay. On the prayer of Mr. S.D. Purkayastha, the learned counsel appearing for the petitioner, let the case be listed after 2 weeks. In item 59, you write, you are Mr. Mr. S.J. Chaudhary submits that the senior counsel, Mr. J. Kamar is out of station. Let the matter be listed after 2 weeks. Interim order so passed earlier shall continue till the next date. Hmm. Hmm. No, no. Okay, we'll see like, if we can take it up. I mean, we'll go by this thing. If we'll try. We'll try. Hmm. CD is 37, right? CD is not available. Let the matter be listed. Let the matter be listed on. Huh? Charge is submitted. Then we'll take it up when the matter comes. And with regard to item number 38 and 39. 13? 38 and 39. 38 and 39. Yes. 38 and 30, 39. And 39. 38 number 38 and 39, CD not available. Let the matter be listed on 12th. 38 and 39. Interim order so passed earlier shall continue till the next week. Please. Hmm? 48 case there is not received. Let the matter be listed on. Let the matter be listed on 13 March. Interim order is there. Listed on 8th, 10th of March. No, 8 is a holiday, 10th of March. On the prayer of the learned counsel appearing for the accused applicant, let the matter be passed over for the day. And let the matter be listed on 11th. The 42 CD is not available. Let the matter be listed on 17th March. Item number 62. Yes. Yes. On the prayer of the learned counsel, on the prayer of the counsel appearing with the accused applicant, let the matter be listed. Not tomorrow. Let the matter be listed on 6th of March. No, that's fine. I mean, not possible. 9th, 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 9th. 9th of March. When? On 27th. Okay, the learned counsel appearing for the accused applicant submits that she should be allowed to withdraw the instant application. Prayer is allowed, matter is dismissed as withdrawn. Day after tomorrow, not possible. 26th. 26th. 19. Yes. Okay. Under prayer of so and so, let the matter be listed. Let the matter be listed on first week or second week on 12th of March. Interim orders so passed earlier shall continue. $50. Yes. On the prayer of the learned counsel appearing for the accused applicant, let the matter be let the matter be adjourned for the day and to be listed on 5th of March. No, tomorrow, day after tomorrow, no. No. It will be listed on 26th. 26th. No, not possible. We have already given. CD is not, item number 24, CD is, Mr. Parasa, CD not available? CD not available, CD is not received, huh? CD is not, CD not received. Let the matter be listed on 16th of March. Interim orders of past earlier shall continue till the next date. No, tomorrow not possible. Lot of matters have been already fixed on tomorrow. 26th. Item number 64. On the prayer of the learned counsel, let the matter be listed on 25th. 25th. Hmm. Hmm? Hmm. Injury report will be required. Okay. Write these 3 matters and list the matters on 9th of March. 9th, injury report will be required. 9th of March. These 3 matters. Huh? 3 matters. 3 matters or 4 matters, please. 4 matters are linked. Yes.
Motion B, item number 1.
Hmm? 31. 31 and 51, it will be taken up when the hearing is taken up. No? These matters will be taken up when the hearing is taken.
Number 2.
It is the same case. Just 48 notice. Right, heard Ms. L. Bonic, the learned counsel appearing for the accused applicant, also heard Mr. K. K. Parasar, learned APP for the state. Then you write decision application and you write it, huh? Decision application and so and so. Then you write the prosecution case is there in page 33, para 3. Hmm? Then you write para 4, para 5. Then para 6. Para 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, same, huh? This, till the 15, 16, 17. Okay, same order it will be. So he was arrested from the spot, same spot, right? Same spot. It will be disposed of. All these people were arrested the same day, no? 3rd, 14, 12. See, Delhi High Court has come up, Delhi High Court Division Bench has come up with a judgment when it has says that Mihir Shah's case will be applicable prospective. So no more reliefs on the basis of Mihir Shah if arrested earlier. We'll follow that case, follow Delhi High Court Division Bench. Yeah, latest case.
Item 3.
Okay, heard me, you write hard so and so. This is an application, under so and so. Case relates to rape of complainant's daughter by the accused applicant. Rape. Let the notice be issued on respondent number 2 through the registry as per the prevailing so and so. Okay. Notice to respond number 1 dispensed with because APP appears. Registered call for TCR in connection with special POCSO case number 170-12025 from the court of the learned special judge POCSO, Lakhimpur, not Lakhimpur. Let the matter be listed on 17th March.
Item number 4.
To the same, the same spot. Then you can, that item number, that all the paragraphs we've given. Same 47 notice. Okay, this will be disposed of, allowed, huh? Same order will go. Yes.
5.
Who is the main accused? And these people are? Mr. E. Khanikar, the learned counsel appearing for the accused applicant. Is the same matter, Mr. Parasa? E. Khanikar, so and so, when APP, this is an application under so and so. The brief facts, you take it from para 3, huh? Page 37, para 3. Correct, wait. No. Para 4 you take. then para 4, you can continue on para 4. You take it from here, then can you write the learned counsel appearing the accused applicant submits that the accused applicants have been arrested on. Accused applicant number 1, 17, and 2, 16, and 3. But others have been, let him go, let him go. Place 18. It is regarding the Scooty thing, right? Scooty and submits the so and so arrested so and so. He further submits that some of the co-accused, including one of the prime accused, Iftikhar Hazarika, namely Iftikhar Hazarika, has already been granted anticipatory bail by this court on 16/2/2026. Full stop. He submits that since all the accused applicants involved in the same alleged offense and the co-accused have already been granted bail, the present accused applicants will be also granted bail. Learned APPK KK Parasar submits that there are materials against accused applicant number 2. He submits that therefore he opposes the bail to the accused applicants. This court, after considering the submissions made and in consideration of the CDs, no, CDs not there. Yes. In considering the facts and allegations, as well as of the fact that that co-accused has already been the co-accused, who is one of the prime accused named in the FIR, has already been granted. These 3 people are named in the FIR? Well, to be allowed to be go in bail. Since one of the co-accused who is the prime accused as alleged in the FIR, this court is able to consider too that the present accused applicants should be granted bail at this stage. Accordingly, it is directed that that the accused applicants shall be released from jail on furnishing of bail bond of ₹50,000 with one surety of like amount to the satisfaction of the arresting authority. That was satisfaction of which court? To the satisfaction of Chief Judicial Magistrate, Tezpur, subject to the following conditions. Subject to the condition that the accused applicant shall cooperate with the investigation and shall not try investigation and shall appear before the investigating authority as and when required. Full stop. In view of the aforesaid, this instant bail application is disposed of as allowed.
Item 6.
Okay, heard Mr. Anjay Datta, learned counsel appearing for the accused applicant. Also heard Mr. KK Parasar, learned APP for the state. Please an application under so and so. Then the case relates to what was the allegation? Some ganja was recovered. Okay. The case relates to recovery of recovery of certain amounts of 19 small packets of suspected ganja from the possession of the jailer, and 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 the accused applicant has also been implicated in the incident case. Call for the CD. Let the matter be fixed on 6th of March.
Item 7.
Heard so and so. Heard so and so. There is an application under so and so. Then the case relates to. The case relates to. Case relates to alleged use of malicious software and cryptocurrency platforms to launder illicit funds. Full stop. Call for the CD. Let the matter be fixed on 10th of March.
Item 8.
Heard Mr. So-and-so, the land council. And now we are issuing notice in this case. So do we heard Mr. Dubey, the land council, preparing for the accused.
My lord.
Also heard Mr. K.K. Parasar and APP. This is an application under so-and-so. The case relates to alleged dacoity. Also call for the CD. Let the matter be fixed on 11th March.
Item number 9.
Heard Mr. So-and-so. This is an application under so-and-so. The case relates to. Case relates to.
Cái number là cái máy tắt vô lệ để mà
Case relates to alleged demand of dowry and assault on the victim girl. By husband, he's a husband. Hafizur is the husband. Victim woman by the husband. Registry to call for TCL in the instant case from the court of learned session judge Borpeta. Let the matter be fixed on 12th of March.
Item 10.
There is no fixed rate. Since then, there is already 3 months, 23 days apart. Moreover, other all the units have been released. Recently on this 31.
That okay, what I mean, the default period is over. The default period of what? It's a default bail.
Released from. He's on the way now.
No, what was the allegation? How many days behind the bars? Huh? Page 33. How many days already?
23 days. He is already late. He said not that 31, another 3 days to delay. But another
Yes, let him go, Ms. Parasa. Heard Mr. So-and-so, and Mr. and Leonard APP also. Then you write is an application. Then you write. You were one of the person who was present.
uh,
103 is there, but two other people have been given bail. Then you have written that it is an application under so and so. As per the allegation made in the FIR on 11/9/2025, a quarrel broke out between the victim and his co-students. So you are also one of the student. You are also one of the student.
Yes,
Co-student.
colleague of someone.
Hmm?
But not a student, and I was a colleague of the one student.
Colleague of one student. You are working somewhere or what?
He was there to just to bring in. That is your friend. Not he is not the untangling the case.
But you are present when the incident happened, right? Hmm? They were there. And his co-students in course of the quarrel, the accused applicant, along with some other co-accused persons, assaulted the victim, as a result of which the victim became unconscious and subsequently died 20 days later in hospital. It is seen from the charge sheet that initially the case was registered under section 109/115(2) stroke 117(2) stroke 189(2) of BNS 2023. However, as the victim succumbed to his injuries while undergoing treatment, subsequently section 103(2) BNS was added, and as per the postmortem report, the date was due to the injuries sustained on head, which were antemortem and caused by blunt force impact. The learned counsel appearing for the accused applicant submits that the victim died 20 days after the incident, and it ultimately may not turn out to be a case under section 103 in bracket 2 BNS, and the accused applicant and the co-accused did not have any intention of causing death of the victim. He submits that all of them are young boys and were co-incidents of the co-students of the victim, and the alleged assault took place on account of certain altercation amongst the victim and amongst the victim, the accused applicant and other co-accused persons. The learned counsel submits that some of the co-accused students have already been granted bail by a coordinate bench of this court by orders dated 30/1/2026 and by order dated 30/1/2026. He submits that since the co-accused students have already been granted bail, this court also should consider the prayer of the accused applicant, who has already spent how many days you said? 3 months in? He has already spent 3 months and 20 days behind the bars. He submits that the incident occurred at the spur of the moment without having any intention of any of the accused students, including the accused applicant, to kill the victim. Therefore, he prays that the instant bail application should be allowed by releasing the accused applicant on bail, full stop. After hearing the parties and taking into account of the fact that the co-accused students who are similarly placed have already been granted bail by coordinate bench after consideration of the CD was there, na, earlier when it was considered, it was there. After due consideration of the materials brought in record, is of the considered opinion that the present accused applicant should be also released on bail. Accordingly, it is directed that the accused applicant shall be released on furnishing of a bail bond of rupees 50,000 with one surety of like amount to the satisfaction of the satisfaction of who? Which court? Charge sheet submitted where? Additional session judge or what? No. Which court? Charge sheet was submitted where? Huh? Kamrup Metro. To the satisfaction of the SDCM. Huh? To the satisfaction of the Chief Judicial Magistrate. Kamrup Metro. Kamrup Metro, subject to the condition that the accused applicant shall regularly participate in the trial and shall not try to influence or intimidate any of the witnesses that may be involved in the instant case. In view of the aforesaid direction, the instant bail application is disposed of as allowed.
Item 11.
How he can authorize you? It's like that. He is not with you. At 2.
Number 56 of supplementary list.
Okay, heard Mr. Deacon, other learned counsel, and also so and so. There is an application so and so. The case relates to alleged rape of the minor daughter of the informant. And you write, let the notice be issued on respondent number 2 through the registry as per the prevailing notification issued by the Gauhati High Court. Notice to respondent number 1 is dispensed with since APP appeared. Call for the TCR in the instant case. Instant case from the learned special judge come additional district and session judge Jorhat. Full stop. Let the matter be listed on 12th March.
Motion AB item 12.
Where means where? This code. Okay. Heard Mr. So and so. How do we find out, Mr. Parasar? It may have gone back last, when was the last date? 18th. It may have gone back. It must have gone back. Heard Mr. So and so. Then this is an application under so and so. Then the case relates to case relates to case relates to case relates to alleged murder of where is the translated copy? Case relates to murder of the son of the informant by the accused applicants. Call for the CD. Later matter be fixed on when? 11th. Okay, 11th.
Item 13.
We'll call for the CD in the matter. Yeah, I've gone through it. Blackmailing, then like having sexual relationship, then all these allegations are there. You are not that person. You are who? You are Abul Hussein. Abul Hussein is named in the FIR. Hmm? You have come for how many people? So Abul Hussein is the father of the main accused. Main accused is Jahidul. Okay. Mother. Uncles.
This is the allegation. And he never comes to your house for any discussing about the vessel. And instead, the informant's house and our house is 30 kilometers away from 30 kilometer distance. And incident of this informant house is the next to the informant. And it is a completely a suicide case, my lord. In fact, this little abnormal that this is guard, my lord. And earlier we don't know, my lord, Maria Professor sees and to commit suicide because her father usually torturing her about her abnormal behavior.
Okay, we'll call for the CD. We'll give a short date. We'll give a short date because I mean allegations are serious. I mean not very. I mean at this stage, I mean without looking into it, it will be difficult. So we'll keep a short date. Okay. Heard MS so and so, the learned counsel appearing for the accused applicants. Also heard Mr. K.K. Parasal, learned APP for this stage. This is an application under so and so. Then you write the case relates to alleged sexual actual alleged rape of the victim girl, and thereafter the commission of suicide by the victim girl. The accused applicants are the father, mother, and uncles of the main accused, that is Jahidul Islam. Full stop. Call for the CD. Let the matter be fixed on when, Mr. Parasal? 9th of March. Okay, 6th.
14.
Hmm? Hmm. Let him go. Heard Mr. So-and-so, learned counsel appearing for the accused applicants, also heard Mr. So-and-so. This is an application under so-and-so. An FIR, the brief fact of the case is that on 8/12/2025, one Hassan Ali had lodged an FIR before the OC Krishna Police Station stating inter alia that on 7/12/2025 at around 2:30 p.m. his father, namely Wahid Ali, while going to his own cornfield from his house, got electrocuted in the wire planted by the name and the planted by all you three are involved, right? The other people are also there. Mm, accused applicants and other persons. And some other FIR named persons for catching fish at Krishna and Pasbari River. Full stop. That full stop semicolon that due to the aforesaid shock, electric shock by the victim, the father of the victim, and the father. It was lost by you. I mean, who has lost it? Mm. The complainant's father died. Full stop. On receipt of the FIR, police registered Krishna PS case number 75/2024 under the aforementioned sections. The learned counsel, the accused applicant submits that though the victim died due to the electric shock, the incident was purely accidental, and there was no intention to kill the accused. There is no intention to kill anyone. He further submits that the element of negligence may have been involved in the incident case, but there is no case of any intentional crimes. He submits that the accused applicants are villagers of the same village of the victim and shall cooperate with the investigation in the incident case. Full stop. The learned APP, on the other hand, opposes the bail application. This court, after taking into account the entire facts into consideration, is of the considered opinion that the accused applicant should be given the privilege of pre-arrest bail at this stage. Accordingly, it is directed that in the event of the arrest of the accused applicants, by the arresting authority, they shall be released on furnishing of bail bond of rupees 20,000 each with a surety of like nature to the satisfaction of the arresting authority, subject to the conditions, subject to the following conditions. One, that the accused applicants shall appear before the investigating officer within a period of 10 days of passing of disorder. Secondly, the accused applicants shall fully cooperate the investigation and make themselves available as and when called for by the IO. Then the accused applicant shall not try to influence any of the witnesses that may be involved in the incident case in view of the aforesaid directions, the instant AB application is disposed of, is allowed.
Number 15.
System then calculates the in item number 2, 5, and 4 minus 11. User method use only and from his house for the 86 kg of minus 86 kg. Here, along with 25 lakhs 25,000.
What is your ground? Then you submit what is, I mean, why it should be allowed? No, no CD is required. I mean, in this case, we have already perused the CD. And then you have fled away. You have fled away. You have been named. You are free from your house. We'll reject this. No CD is required in this matter. We have already gone through the CD and we have allowed many people. No. Your senior, I mean, why you are appearing then? Your senior will appear. We are rejecting this. You just write. I mean, I'll give you. I'll declare in the chamber. We're rejecting it. AB rejected.
16.
Itu rakhi po chamber. Hmm? Allegation is? Hmm? Statement of the victim, where? Page 26. Mr. Pora, sir. Nothing is there. Heard Mr. So-and-so, the land council of accused applicant. Also heard Mr. K.K. Parasol, and APP for the state. That this is an application under so-and-so. And the allegation as alleged in the FIR. FIR is at page? Huh? Page. Page 10. The allegation as narrated in the FIR. Dated. FIR date. Three 12 or 212? Hmm? 3/12/2013. Sorry, 2023. Is entirely that the informant's cousin for the last few years keeping a jealous mind on the family of the informant. Semicolon that on 1/2/2023 at about 8 p.m. the accused applicant entered into the house of the informant with a dao with the intention to kill him. Thereafter, semicolon, that he attacked him with dao and also slapped on his back. That the accused person forcibly took his wife along with him and ran away. That he suffered severe injuries in the alleged incident. Full stop. The learned counsel appearing for the accused applicant submits that this is a totally concocted and false story which has been narrated in the FIR. In FIR, actually, the wife of the mm, wife of the informant had voluntarily went with the accused, went with the accused person, and there was no abduction as alleged has been committed by the accused applicant. In view of the aforesaid, he submits that the accused applicant should be allowed to go on pre-arrest bail at this stage. Full stop. This court has gone through the materials available, materials that have been brought on record, as well as the statement of the victim, statement of the wife of wife of the accused, and wife of the informant made before the police, and on perusal of the material, relevant materials available, this court is of the considered opinion that at this stage the accused applicant should be granted the privilege of pre-arrest bail. Accordingly, it is directed that in the event of arrest of the accused applicant by the investigating authority in connection with PRC number 122/2024, 24, he shall be released on bail he should be arrested, he should be released on bail on furnishing of a bail bond of ₹30,000 with a security of like nature, subject to the satisfaction of the learned SDM in bracket M, Lakipur, Kasar, subject to the following conditions: that the accused applicant shall appear before the investigating officer within a period of 10 days of passing of this order. Number two, that the accused applicant shall cooperate with the investigation and make himself available as and when called for. Third, the accused applicant shall not influence any. In view of the aforesaid direction, the instant AB application is disposed of.
Number 17.
Item number 15, you write, Mr. Ayu Chaudhary, the learned counsel appearing for the accused applicant, submits that he has instruction to withdraw the instant AB application. Accordingly, the instant AB application is dismissed as withdrawn. A 15, you just note that matter. That you. Okay. Okay.
7 of the Navy.
Yes.
Father and son has been voting, the father got absolute bail. That order is also will find a place to the extreme. Why? One of the reasons, because of some and
Who has got the bail? Who has got the bail? Father. Father was named in the FIR. And he is the son. Okay. Okay, heard Mr. M. Biswas. Mr. Parasar, father has already been granted, and accused similarly placed. Yeah, that field, no, I mean field. Mm. But he enticed the son to attack. Mm. Mm. Mm.
Nine.
Mm. Mm.
How come I take it? If there is an injury, my lord, then my lord, investigation is over. If they are admitting what the injury is. No injury. I have to decide whether the injury will fall for 326 or 323. This case where the custodial intervention is prepared for way back in October, this incident had happened. Rightly coming to show that Father was granted. Father was granted because he is the son of the no. He is the we have to see the after 4 months of the incident, my lord, what purpose it would serve, my lord. Rather than investigation,
Let him go, Mr. Parasa. Not about, I mean, this kind of, but Mr. M. Biswas. Learned counsel for the accused applicant, also heard Mr. K.K. Parasa, learned APP for the state. This is an application you write, huh? You take it from paragraph, page 19. Paragraph 2 you take, 3 you take. Then paragraph 4 you take. Yeah, 4 you just write it. Mr. M. Biswas, the learned counsel for the accused applicant submits that though there is an allegation against the accused applicant of using a DAO and thereby causing grievous injuries on the victim, in fact, the incident occurred due to certain misunderstanding between two neighbors, and the accused, and the victim person has already recovered, and they are living peacefully. Full stop. He further submits that since the incident occurred sometime in the month of October, and sometime in the month of November, and already 3 months have already passed of the aforesaid incident. At these days, the custodial detention of the accused applicant may not be required, as the accused applicant is ready to face the trial if so occurred. On the other hand, the learned APP submits that the accused applicant is the main culprit in the incidents as alleged in the FIR, as he was the person who has given the blow by Dow. Therefore, at this stage, the accused applicant should not be granted bail. Full stop. This court has considered the submissions made by the counsel appearing for the respective parties, has also perused the order dated 18/2/2026 passed by this court, whereby the father of the present accused applicant was granted the privilege of pre-arrest bail. Full stop. Taking into consideration the taking into consideration the facts in its entirety, this court is of the considered view that at this stage the accused applicant can be granted the privilege of pre-arrest bail. Accordingly, it is directed that in the event of arrest of the accused applicant by police or by the investigating authority, in connection with the Dargaon PS case numbers 116/2025, he shall be released on furnishing bail bond of ₹20,000 with a security of like nature to the satisfaction of the arresting authority, subject to the following conditions. Give these following conditions from here, page 20. Page 19 and 20 लिखी है ना, लिखे रहे आप लोग बोले वही क्या लग रहा है K was subject to D. In view of the aforesaid directions, the instant anticipatory bail application is disposed of as allowed.
Bail hearing BA, item number 20.
CD has come. Last 150 days. What is the allegation? Anyways, we'll wait for the CD. CD not received. So in this case, we'll have to wait for some time. CD not received. Lease the matter again on 10 March.
21.
But he's already behind 150 days. Okay, that will be fine. 10th of March is fine. Why up to date? Heard Mr. So-and-so, the learned counsel appearing to the accused applicant. Also heard Mr. K.K. Das, learned APD for the state. It is submitted. The learned counsel prays for adjournment of the matter, stating that the leading counsel in the instant case is out of station. Out of station. Full stop. Prayer is allowed. Let the matter be listed on 11th, on 11 March. In the meantime, updated TCR. In the meantime, the registry to call for the updated TCR in the instant case. Scan copies of the updated TCR in the instant case.
23.
If nobody is there, we'll take it up after some time. We'll wait for some time. None appeared when the matter was called for. Though Mr. R.K.D. Chaudhary, the learned Deputy Solicitor General of India, remained present for NCB. For NCB. Let the matter be fixed next week. Not tomorrow. Let the matter be fixed on 5th of March.
Item number 25.
FSL is there. No, 49 is fine. Heard Mr. T. Som, the learned counsel appearing for the accused applicant. Also heard Mr. K.K. Parasa, the learned APP for the state. Though the case diary is received, FSL report is yet to be, is not available in the case diary. Await for the FSL report, lease the matter again on 5th of March.
27.
The scan copy of the case TCR has come in. Since the investigation is pending with the TCR does not contain anything. The case has been shut.
Case diary has to come. Heard Mr. S. Nawaz, the learned counsel for the accused applicant. Also heard Mr. N. Das, K. Goswami, the learned AP, K. Boisha, the learned APP for the state. Case diary in the instant case is yet to be received. Call for the case diary and list a matter again on 6th of March.
Item number 29.
এটা কেটা আছে সেগুলো দুটা আছে
Page 13 is a case for the
সেই CDS come
only one mobile phone and one night type of recovered nothing. Then you are please to give short that logic because of the variable of the
Okay, another short date. Heard case diary not received. Let the matter be listed on how many days? 54 days. Let the matter be listed on to 25th. 25th.
Item 30.
CDS come? Yes.
Yes, very honest. If I if online game watching and game it is free of it. From online game out of that something to other person. That person I given something.
Who are you all? Hmm. Hmm. You are Vikas Chaudhary and how many of you are there? Hmm. 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 Hmm.
One effective matrimonial, owner of that matrimonial package. Petitioner number 3 presented himself as airport authority. Petitioner number 4 himself presented as your lordship. As per the police allegation, your lordship. Himself as income tax officer.
Hmm.
There is no indication it is petitioner number 5 as per the lordship. In one thing, your lordship, the police has completed its investigation as per the forward, your lordship. But till the registration of the FIR, there is no whisper against this like petitioner's, your lordship. This is the forwarding letter who speaks that like this, your lordship. My point is that
No, I mean, only thing is that you have taken a different name. The problem. Hmm. Hmm.
One number, your lordship, seized by the investigation officer, if your lordship can see the list, your lordship. Is that case number 29, your lordship? 29, your lordship. Is number, your lordship. That number is from one Italy, your lordship. One is from UK, your lordship. One is from Pakistan, your lordship. Neither of the number, your lordship, have been seized from my possession, your lordship. It is the list, your lordship.
How it will be seized? It's all hacking, Pop. It's all hacking. How, if it is hacking, then how it will be seized? Yes, Mr. Goswami.
I got problem. And there are real accounts.
Hmm.
These kind of offenses are real accounts that do there. And they deposited to another
Account.
number.
Hmm.
Here it is, yes, how they have come to their name come.
Hmm.
Their nothing.
Now, where is that?
Nothing. Because this person's, the complainant has given the QR code.
Hmm.
And UPI IDs are also there.
Hmm.
Police investigated that lawsuit, and by that lawsuit, they found this person. And after that lawsuit, they have already said that they have been with us money, and they further transfer it to another account. So all of these persons are involved. And police have also stated that lawsuit. Cyber cell has recovered one ICICI note which found where another one number is found. I will not disclose. One number is found lawsuit, and they are police are now investigating on that number lawsuit.
The investigation is not complete. Heard Mr. G. Bora, the learned counsel appearing for the accused applicant. Also heard Mr. K.K. Das, the learned APP for the state. There is an application under so and so. And FIR, the allegations as allegation. See, please, I have given you sufficient time and I'm not going to hear you anymore. Okay, and then we don't need to speak about procedural part. We have got to know it. Investigation is still on. This court is not in favor of giving any kind of relief to this kind of cyber crimes. Okay, this is happening every day rampantly. The judge's account has been, the senior lawyers have been hacked. No, there are strong link and strong suspicion on you people. So at this stage, I mean, bail cannot be granted. We have made up, this court has made up his mind. So please don't disturb. If you want to challenge this, you go and challenge this, but please don't disturb when it is dictated in detail. Heard of so and so. This is an application under so and so. The case relates to filing of an FIR. The case relates to cheating of the complainant of several of huge amount of money by using different mobile phone numbers by the accused applicants. Accused applicants falsely identifying themselves as persons staying in Italy, UK, and other foreign places, and cheated the victim informant, stating that one of those persons will get married, will marry her, and thereby invited her to Delhi, and kept on asking her for certain amounts to be deposited to certain accounts. The money have been deposited by the informants on the belief that the person will come from Italy and she will go to Delhi to meet him. But however, later on she realized that there is a big big fraud has been committed to her, as several persons are involved and introducing themselves as highly placed officers, and thereby duped her of s- of of more than a lakh of rupees, more than 2 lakhs of rupees. Full stop. It is on the receipt of the FIR, police registered. Police registered Lanka Police Station case number 225/2025, 25 under the aforementioned sections. The learned Mr. K.K. Das, the learned APP, submits that the case is still in a very nascent stage and investigation is still going on. And since that a huge racket is involved in the instant case at this stage, the bail to the accused applicant should not be granted. On the other hand, the petitioner, the counsel appearing for the petitioner insists that nothing incriminating has been recovered till date by the investigating officer from the accused applicants, and therefore, since they have already spent, how many days you were there? Huh? They have already spent more than 39 days behind the bars. They should be allowed to go on bail at this stage. This court has heard the submissions made by the counsel appearing for the parties, has also perused the case diary in the instant case, and having found no merit for granting bail to the accused applicants at this stage, the same is rejected. Disposed of.
Item 32.
Yes.
Degree of the disease. And one folder at the motion or a communication is 6-3.
6-3. Okay, we're passing it for time.
33 and 34.
TDS come. Okay, let that come. I mean, the allegations are serious. Allegations are serious, Mr. Nawaz. I mean, like this. I mean, I don't want to spend time on that. Let the postpone when it will come. See, he was detained. He was detained, and allegation is that later on he was found dead, assaulted and found dead. So we'll have to see the postmortem. Mm. Mm. Mm.
In which this person had
Mm.
to see this person, he was perhaps with he was fought by the people of their outcome this time. Then all of the
But you have allegation against you also. You were part of the mob. Correct? You were there. You came to the place. Mm. Mm. Mm.
of that person, how this
They
had tied him up. When the person was tied up in that area, then all the neighbors in that area, they appeared, they came to the city. I had a police appeared as silent. Thinking that there is a thief fellow.
They must have bashed him up. I mean, that's what.
This is not a case that should be arrested. When the other person is arrested, okay, we see it is 21 and before the court.
What is your name? Ajoy Dekaraja. I mean, you are a neighbor. No, no, no. In whose house this?
This is other data.
And you are? I mean, you are a neighbor.
I'm already
39 days.
also that. And this fact is also not good, right? Because the further detention is coming. Another coexistence is already increasing. Similar to definitive labor, like that person is on interim leave.
34 with this.
Same labor.
First, this order কিন্তু গাঁৱৰ মানে মানৰ পাছত মানুহজন অচেতন হৈ পুৰা সকলোৱে এৰি গুচি যায়। পাছত মই আৰু আনসকলে দাঙি পেলাই ডেকৰাজাৰ ঘৰৰ কোনোবা খেৰ দি খুৱাই থওঁ। ৰাতিপুৱা উঠি দেখা পাওঁ মানুহজন খেৰৰ ডোবত মৰি আছে।
The case of negligence, case of there are already 39 days, Mr. Parasar. And he is a neighbor also, is not in the house. And there is no, I mean, direct allegation that he has, I mean, he has, and he has surrendered also himself. Surrendered. The conduct is also to be taken into account. And your attempt, you are already on an interim bail. She is a lady, Rangmai. You are the wife of this person, the Ajay Dekaraja. Okay, heard Mr. S. Nawaz, the learned counsel, appearing for the accused applicant, also heard Mr. K.K. Parasar. This is an application under so-and-so. The allegation as stated in the FIR is that on 5/1/2026, an unknown person entered into the house of one Ajay Dekaraja, and thereafter a commotion took place, and the said person was tied up and assaulted by some persons, causing grievous injuries, and subsequently, the said person was found dead about 50 meters away from the house of the said Dekaraja. Full stop. Mr. S. Nawaz, the learned counsel, appearing for the accused applicant, submits that the accused applicant is only a neighbor of the aforesaid Ajay Dekaraja, and he is nowhere involved in any assault on the victim person. He submits that in fact the accused applicant has himself gone to the police and surrendered gone to the court and surrendered before the court after the death of the victim also. Victim. Case diary in the instant case has been produced, and taking into account the materials before this court, as well as on hearing the submission made by the counsel for appearing for the respective party, this court shall reserve the considered opinion that since the accused applicant has already spent more than 39 days behind the bars, and he has voluntarily surrendered before the court, and there is no specific and direct allegation of assault against the accused applicant, this court is of the view that the accused applicant should be allowed to go on bail at this stage. Accordingly, it is directed. Yeah. No. Okay. क्या लिखा last में? It is directed to release the accused applicant on bail on furnishing a bail bond of rupees 20,000 with a security of like nature to the satisfaction of Lanet CGM, Nagaon, subject to the condition that the accused applicant shall cooperate with the investigation and appear and make himself available as in when called for by the IO. IO and he that will be fine. In view of the aforesaid direction, the instant bail application is disposed of as allowed. Then you heard Mr. A. Sharma, the learned counsel for the accused applicant, also heard Mr. K.K. Parasol, learned APE for the state. Then this is an application you write, that same FI, same this thing. Then you write that the petitioner is it is submitted that the accused applicant is a neighbor of the said Ajay Deka and is a 67 years old widow and who has no connection with the instant case. It is seen that by an order dated 9/2/2026, a coordinate bench of this court has already allowed, already given interim protection to the accused applicant. And in terms of the aforesaid interim protection and direction, the accused applicant has already appeared before the IO and got her statement recorded. Full stop. Full stop. Taking into account the aforesaid facts, this court is of the considered opinion that the interim order passed interim PRS bail that has been granted to the accused applicant should be made absolute. Accordingly, the order dated 9/2/2026 is made absolute in the same terms and conditions as mentioned in the aforesaid order. Consequently, the instant AB application is disposed of as allowed. I'll just come within 5 minutes.
$35 and $36.
And about for 70 days. Admittedly, there was an accident. Motor side accident insurance. I asked about
70 days already. 70 days. Some scooty, yes. Then some people came in like best demo.
All the injuries are there.
He recovered.
One of the statement is there, other statements is not there. We are minor, that is the team method. Yeah. So my other are also minor. Can you see the note and on the part 5? And along with that, the group of people who are associated with the main person, whether it is petitioner minor. In the minor, other minor, item number 36, one is for the PRS state application minor, one other board only minor. He is very much involved with that. And on the severe analysis on the repeatedly on the particular date minor, the police able to connect all through call with also. Safety in the minor highway, is the minor the king man. That happened minor. And when the people come moments, sometimes it may minor occur. The situation is that minor forming a minor wounds minor and using minor, that is the types and all other things minor. The assault It was from the side of the homicide. In our FIR, everything has been explained. And they all were tranquilous. And they first started the assaulting the president. There is evidently there was an accident in system. 5%. As per the application, most of falling off some presidents.
In the Scorpio, how many people are there? 7 numbers of people are there. And who got injured? Three.
Thereafter, they called the policeman. Even thereafter, from there, they were shifted to.
But already 70 days. Heard Mr. D. Das, the learned counsel, appearing for the accused applicant. Also heard Mr. A.K. Das, the learned APP, sorry. Mr. Goswami, the learned APP for the state. This is an application under so and so. An FIR was lodged on 15/12/2025 by one Muhammad Shah Nawaz, alleging inter alia that on 14/12/2025 at about 11 p.m. when the informant along with 6 other persons were returning back from Joy, the main accused, whose name was not mentioned in the affair, allegedly riding his scooty bearing registration number AS 08A7962, allegedly hit the Scorpio driven by the informant from the left side, and thereafter the main accused, instead of apologizing to the informant and others, allegedly called his gang members by making a phone call, and subsequently around 15 other peoples, along with the main accused, allegedly assaulted the informant and others using deadly weapons, causing injuries on them. On receipt of the FIR, next para, a case, Vasista Police Station case number 598/2025. The aforementioned sections were registered. The learned counsel appearing for the accused applicant submits that the accident, admittedly there was an accident, and due to the accident, some commotion took place between the informant and the informant and the accused applicants. How many were there? We have come? Only one. Between the accused person, including the accused applicant. Commotion took place between the informant and the accused persons, including the accused applicant. He submits that accused applicant was also one of the person who was traveling in the vehicle, and he's not connected. He's not connected in assaulting the informant. Full stop. He submits that since the accused applicant has already spent more than 70 days, spent 70 days behind the bars, at this stage, the further custodial detention of the accused applicant may not be required. Full stop. The learned APP, on the other hand, submits that there are materials in the case diary which suggest the involvement of the accused applicant in the assault of the informant. Therefore, at this stage, the accused applicant should not be granted bail. This court has heard the submission made by the respective counsel appearing for the parties as well as gone through the materials brought before this court by way of by way of the case diary. Also, considering the whole facts of the case and taking into account that the accused applicant has already spent 70 days behind the bars, this court is of the considered opinion that at this stage the accused applicant should be granted bail. Accordingly, it is directed that the accused applicant be released on bail on furnishing of a bail bond of rupees 30,000 with a surety of like amount to the satisfaction of CJ Kamrup Metro, subject to the condition that the accused applicant shall cooperate with the investigation and shall not try to influence any of the witnesses involved in the instant case. In view of the opposite direction, the instant bail application is disposed of as allowed. AB.
When we have to
Same, you did right. The applications, heard so and so application, then write about the FIR, that whatever it is in there. Then you write to the learned counsel, if any the accused applicant submits that the accused applicant, the present accused applicant was in fact not inside the vehicle, and he went to the incident to the spot of occurrence on receipt of a call from his brother who was traveling in the Scorpio vehicle. He submits that he is no way involved in assaulting the accused, the informant, and he went there only for the purpose of inquiring about the incident and on receipt of a phone call. Therefore, he submits that the accused applicant should be allowed to go on pre-arrest bail at this stage, as custodial detention of him may not be required in the instant case. On the other hand, Mr. Goswami submits that
severe crisis along with the fixed minor between Saturday and minor. And minor this is fine as because it is not a case of only the minor the rider and the minor the
other people also came in.
So at this case minor may not be drafted bail
submits that the accused applicant in the instant case, and though was not traveling in the vehicle which met with an accident, he went there on receipt of a call, and there are sufficient materials to suggest that the accused applicant was involved in assault of the informant. Therefore, he submits that at this stage the bail at this stage pre-arrest bail should not be granted to the accused applicant, as he may be required for custodial. He may be required for investigation at this stage. Full stop. This court has gone through the materials, gone through the case diaries which has been produced before this court, as well as heard the submissions made by the respective parties, taking into consideration of the fact that that the accused applicant was called by his brother, who was traveling in the Scorpio vehicle, which made. No, he received a phone call, right? And how does it matter? Scooty or something?
Scorpio vehicle was driven by the informant side, and the scooty was driven by the and he's the brother of the expert side.
Correct. I mean, he was not traveling there. He went to the place of occurrence only when he received only when his brother met with an accident. Brother mainly, namely the Bijoy Bodle, right? Bijoy Bodle met with an accident. Met with an accident. If other submits that he will fully cooperate with the investigation and fully cooperate with the investigation in the instant case, and therefore he should be allowed to go on bail also. Considering the entire facts of the matter and facts of the, I'll just improve it, thoda sa, idhar udhar karna padega. The case of the matter, this court is of the considered opinion that at this stage, the custodial detention of the accused applicant is not required, and accordingly, it is directed that in the event of his arrest by the investigating authority in connection with Bosisto PS case number 598/2025, the accused applicant shall be released on bail, on pre-arrest bail, on furnishing of a bail bond of rupees 30,000 with a severity of like nature, to the satisfaction of the arresting authority, subject to the following conditions: that the accused applicant shall appear before the investigating officer within a period of 10 days of passing of this order. The accused applicant shall make himself available as and when called for by the investigating officer. The accused applicant shall not try to tamper with the only dinner. Okay. In view of the opposite direction, the instant bail application is disposed of, CD to be called sent back.
Timing items 17 and 18.
Yes. No, not an issue, not an issue. So which one is yours? Both you, I mean, you.
There was a case of disproportionate property sold for item number 18 is sir. That case, the matter was investigated, my lord, and thereafter, my lord, in that case, I was granted anticipatory bail, charge sheet was submitted. And in the charge sheet, my lord, this item number 17 exists, my lord. My wife and two other family members is also being charged. So we are facing the trial, my lord, all along we are attending that particular case. Now we have received the summons, my lord, will kindly come to at page 133 of item number 17. This is the summons that is
133.
one starts from my lord 130. 130 my lord, and then three.
Yes.
Number one, my lord, and at page 132, my lord, we can see there's a list of documents coming from Saraswati Department. Now, this with regard to the vigilance case, my lord, as your lordship very well knows, that the main case is a predicate case, right? If when I am admitted in the disproportionate case, this goes alternately. But whatever it is there, my lord, they have the power to investigate. I have applied for the certified copy of the FIR. I didn't get it, my lord, in special judge court. Then there's a judicial judge, my lord, who tries the PMLA matter. So whatever, my lord, I have received the summons.
So like the fact is that like in one vigilance case, you have been already acquitted.
No,
And that investigation is going on. And you are cooperating with the investigation. And there was another case which has been on the basis of the same facts and same materials. Another case has been lost.
That's part of the record. We have added the charge sheet, we'll show it from there. And they called me, my lord, I made a statement, my lord, that I will cooperate. No worship as a son. That's all, my lord.
My lord, PMLA is the stand alone case. The first thing. What the basic case of the petitioner here is that, my lord, he and she both, my lord, have sought the ECIR. ECIR is, my lord, no, it's not an FIR, my lord. From an FIR, under PMLA, enforcement director, they create a file that is called enforcement case information report, ECIR. That is what they sought for. Now, my lord, what the Supreme Court says that regarding the, is it mandatory? Do you need to give it to them? My lord?
No, I didn't get it. What?
Whether ECIR, is it mandatory that they will seek for ECIR? That's why, my lord, it's not an FIR, it's an internal document of the ED.
No, the only prayer is that already there is a case going on.
Yes.
Okay. And they are participating in the aforesaid case. I mean, they are participating on the basis, I mean, you have been granted bail. Mm,
We are appeared
mm.
and it is for supply of document. Some part of the.
So
document is
documents are seized. And now you show me that, like, I mean, that this case has been filed on the basis of the same case?
Yes.
From where you can show it?
There is no FIR here.
Correct, FIR is not there, but. Hmm.
85 or what, right? You see, and I will come to the sum. 85
Mhm.
Right. Later received from Santosh Chaudhary, so and so, MR number, so and so, salary details, vehicle details and others.
Hmm.
Now, 10, 11, these are all the documents that has to be produced, my lord.
Hmm.
Not to goes to summon.
Someone is where? Well, if you say 132. What? So 132 is a summons to Saraswati Chaudhary. Is a type copy or what? This is? Type copy. Hmm. Not 131 is the original copy, right? Photocopy of the original. Then what is this 132?
Documents to be, my lord, at the time, my lord, 24, 23, 26, these are the.
But this is annexed with the summons,
Yes, yes, this part.
part of the summons.
Of my lord, the court. These are prosecution documents in the, my lord, disproportionate case. Of which I have been facing, my lord, at the authorized state. I will be appearing. And all the summons also, my lord.
So ECIR was filed. Yeah.
ECIR was based.
Hmm.
ECIR is based.
Hmm.
ECIR, my lord, is the document, internal document of the Enforcement Directorate, which is raised on a predicate offense.
Hmm.
We do not, my lord, file FIR.
Yeah, correct. ECR will be filed in a court. Yes. Then. Hmm. Correct.
We cannot. That is bad, bad.
Okay.
I have, my lord,
Hmm.
I need hope for the judgment.
No, that is fine. ECR is a document which is not to be disclosed to the accused. Okay. Because it will go to the directly to the court and court will raise a PMLA case. Then.
ECIR, my lord, it will be registered. And
That's what I'm saying. It will be, the case will be registered. Hmm?
when we raise file prosecution complaint, then
See, one FIR will be there, any kind of, listen to me, let me understand. One FIR will be there on the basis of that some investigation will be done. Then after the investigation, if they find that there are allegations of money laundering, there is an allegation of certain things, then one ECR will be filed before the jurisdictional court. Correct? That will be filed by the prosecution saying that a case should be registered, and then trial will proceed, isn't it? Complaint case there. So that will be filed before a jurisdictional court. Then the complaint, special just court. Correct. So then the case will proceed. The case will proceed. Now he's saying that the ECR cannot be given. Okay. Understood. So you are saying on the basis of Supreme Court only. Correct. Correct.
now
Hmm.
we have the authority, my lord, to go. His cases that already he has got a anticipated bail.
That's in the original case, main case.
When we go ahead with the PLMA, what we can do, my lord, that is also Supreme Court has laid down. I will just read from the Constitution, my lord, what are the direction of Supreme Court in Vijay Northern Law. That is the, my lord, court.
So you have received the summons from where? Then from the court? From the enforcement director. Okay.
To appear with these documents. They are fixed.
My lord, Supreme Court has reserved the prayer for grant of bail, irrespective of the nature of proceeding, including those under section 430 of 1973 code, or even upon invoking the jurisdiction of the constitutional court. The underlying principles of Victoria section 45 may apply. 45 of PLM. So now, my lord, I will read what is section 45. My lord, and PLM.
PMLA.
So my lord, basically, the thing is that we have only given him a sound. He has to appear before the my lord, before the IO my lord under the act. Whatever document we have, he has to give. So my lord, we have under now section 45. Offense of the to the community offense and non-available, that is violent restrictions. Not concerning anything concerning the code of criminal procedure 1973. No person accused of any offense under the act. So my lord, these are PC. He was my lord arrested under PC Act. It's a schedule offense, predicate offense under the PLN Act also. That. So my lord, we can go ahead with this investigation. No person of an office shall be released on bail on or his own bond unless the public prosecutor has been given an opportunity to oppose the application. Where the public prosecutor opposes the application, the court is satisfied that there is a reasonable ground for believing that he is not guilty of such offences, that he is not likely to commit any offence while on bail. So my lord, here the thing is that we have already issued a summon, my lord, appear before the IO to give the documents. This PMLA is, my lord, the case is based on some PC Act, my lord. There is already a pending trial. So at this moment, my lord, my prayer would be
He is only asking for no coercive action to be taken, he will appear.
my lord, okay, my lord. Tomorrow, during the course of investigation, we have arrest to power also, no? We have the power to arrest. So, my lord, during the course of investigation, what comes out is not the my lord. Let him, at least, if he doesn't go, let him supply the documents. My lord, the law doesn't, my lord, bar us from arresting him. There is the thing. So, we have to take the money, my lord.
See, the main predicament offense, that is under the PC Act, correct? So in the PC Act,
In the convicted from what my lord? Money will not be recovered, but we are going to recover the money.
no,
And
correct,
these are all government money, my lord.
correct, correct,
So that is why this.
no, correct,
Council, my
no,
lord.
correct. See, in the main predicament of offense, he has already been granted bail. He is appearing. Now you have done an investigation. You have found certain materials against him, and you have filed this ECIMR, right? Now you are asking him to appear with certain documents. The only thing is that he is asking that I will cooperate, and there should not be any, coercive action against him at this stage. So that whether that PMLA, the rigors of section 45 will come at this stage or not? I mean, whether any PMLA case has been already registered?
My lord.
No, whether you have filed any, complaint before before the sessions, the concerned court. You have not filed. Now this, is there any case registered under PMLA? No. ECIR is fine. On the basis of the ECIR, there has to be a case registered. Oh, no.
18. This GW, this is the case number, my lord, already registered.
Which one? Which one? This is a summon so and so, GWZO.
I am 18, I'm 18.
18, Page 1.
Left-hand side ballot, F, number D, EWZO 122-113. This is the case registered ballot. This is the case number. This is our internal document ballot, ballot. This is the case. This is the ECR number.
What, I mean, that ECR is there with you?
No, man, they.
Understood my lord, and you that a person into summer, and I do not have the right to leave.
That is Supreme Court says, not my mind.
No. So far with regard to the procedure of normally is concerned by law, every ECI number by law, within a reasonable time is to be reported to the court having jurisdiction, then special judge, wherein we apply for the certified copy by law, and thereafter we get the certified copy. And any law with regard to this minor, we have to invoke, we can invoke our statutory right, constitutional right, legally.
My lord, Supreme Court says supply of the copy of PCI in every case to the person concerned is not mandatory. It is enough if ED at the time of arrest discloses the ground of arrest. That is what Supreme Court says, my lord. In a three-judge bench decision, and which is holding the bill. That is the law I have said to them. It's a very clear law, my lord.
See, I mean, Mr. Bhuyan, let the, this thing come, case record come.
Yes, madam, that period I may be protected at point 24, 25, 26.
When is the next date given?
And we are giving another thing to cooperate, what else is required? And the summon is been issued under section 50 of the PMLA. And in that case, my lord, if I go by the summon and respect the same and cooperate, my lord, there is no question of arrest also.
What should this be?
They
The summon.
they have the apprehension because for that purpose, 230 has been made, my lord. Otherwise, it will be minor. It is not problem.
That's what one of Supreme Court says. Even if there is 438, we can still go ahead.
Yes.
It's a standalone.
See, Mr. Dhor, we will protect him for the time being. You bring those records because we'll have to, minutely peruse what is there. It was only for this purpose. Only, let him submit documents and you don't take any coercive action till that time. And after the query comes, then we'll decide. Only for this. Only, only till the next date of listing. They will appear and the 24th and 25th they will appear. And 26th, then we fix up the matter on maybe on 2nd of March. Is it okay? 2nd of March, you bring the CD, then we'll decide. Heard Mr. A.K. Bhuyan, the learned counsel appearing for the accused applicant. Also heard Mr. R. Dhor. You are appearing as a R. Dhor, retainer counsel of Enforcement Directorate, Directorate, full stop. This is an application under, you write, application under so and so. Application under so and so. The case of the accused applicant is that in the year 2015, a preliminary inquiry was registered against the accused applicant on the basis of a complaint dated 8/3/2015 filed by two persons, namely Partha Gogoi and Deepak Das. That uh, uh, after 5 years of registration of the preliminary inquiry, the investigating agency registered a regular inquiry being RE number 02/2020 and commenced and started the investigation. After a period of 4 years, the accused applicant came to learn that the aforesaid RE regular inquiry had been converted into a formal FIR and CM Vigilance PS case number 4/2024 under sections 13 in bracket 1 in bracket small b stroke 13 in bracket 2 of the Prevention of Corruption Act 1988 had been registered against the accused applicant. After coming to know about the aforesaid FIR, the accused applicant apprehending arrest in connection with the aforesaid case preferred an anticipatory bail application and wide order dated 24/2024. This Honorable Court has granted him the privilege of pre-arrest bail. In terms of the aforesaid bail order, pre-arrest bail order, the accused applicant appeared before the investigating authority and his statement was recorded by the IO. Then you write, after completion of investigation and after seizure of necessary documents, the IO submitted charge sheet in connection with the aforesaid case, which was registered as special case number 57/2024. Accordingly, the learned special judge took cognizance of the offenses against the accused applicant under sections 13 in bracket 1 in bracket B stroke 13(2) of the PC Act. The accused applicant appeared before the learned special judge Assam on 21/2/2025, and on the same date, he was allowed to go on bail. And since then, the accused applicant has been regularly appearing on each and every date fixed in the said case. Next paragraph. The accused applicant recently received summons issued by the Directorate of Enforcement calling upon him to appear and give evidence and to produce records in relation to investigation or proceeding under the Prevention of Money Laundering Act 2002. However, in spite of their best efforts, the accused applicant could not ascertain whether any ECIR all capital or complaint had been registered by the Directorate of Enforcement under the Prevention of Money Laundering Act. Understood? being apprehensive of being on receipt of the summons, apprehending arrest, the accused applicant has approached this court by filing the instant re-arrest bail application. Full stop. Mr. Mr. A. Bhuya, Mr. A.K. Bhuya, the learned counsel appearing for the accused applicant submits that all throughout the accused applicant has been cooperating with the investigation and has investigation during the investigation, as well as when the case was as well as when the PC case was registered before the trial court. He has been participating in the trial on each and every date. Full stop. He submits that he submits that his conduct all throughout has been exemplary, and in view of his conduct, the accused applicant was in fact granted bail by the learned trial court. Therefore, he submits that at this stage, uh, he should not be treated with any coercive action by the investigating authority, and this court should consider his case for allowing him to go on a pre-arrest bail. Full stop. On the other hand, the learned Mr. Ardhar, the learned counsel appearing for the accused applicant, and the learned Ardhar, the learned counsel appearing for the ED, submits that PMLA, that the PMLA case which has been registered against the accused applicant is a standalone case, and the case will proceed on its own. He submits that since only summons has been issued in the instant case to the accused applicant, requesting him to submit certain documents, the accused applicant does not have any genuine apprehension of his arrest. Therefore, at this stage, his prayer for anticipatory bail should not be considered by this court. Any other submissions? See, your submission is basically that, I mean, the PML is a standalone case that process will go at its own way, whatever way. And secondly, you are saying that only he has been summoned for appearance and there is no apprehension of his arrest. That's all. Correct. Well, he doesn't have any appearance. So, I mean, why should the court consider his bail, right? Okay. Full stop. This court has considered this court has considered the submissions made by the counsel appearing for the respective parties, as well as gone through the materials brought before this court, along with the anticipatory bail application. Full stop. Having found that the accused applicant has already been granted bail in the case which is pending before the special court Assam, and the accused applicant has been regularly attending the aforesaid trial, and since he has some apprehension about his arrest in the instant case, at this stage, this court is of the considered opinion that the accused applicant can appear before the IO in terms of the aforesaid summons and produce the documents, or submit the documents whichever has been called for in the summons. However, till the perusal of the case diary, which is directed to be produced before this court by this court is of the considered opinion that till his appearance before the investigating officer, no coercive action should be taken by the by the accused, by the ED, ED against him at this stage. In view of the aforesaid, it is directed that the accused applicant shall appear before the IO on 24 and 25, 24, on 24, 25 and 26 in terms of the summons dated, in terms of the summons dated 10th, right, 10th February. The summons dated 10/2/2026 and provide the necessary information as well as documents before the IO. It is also made clear that in the event of his failure to appear before the IO, the ED will be at liberty to take any action as it deems fit. Call for the case diary in the instant case. Call for the case diary in the instant case. Let the matter be fixed on 5th of March. I think that will do. Let him appear and he will produce the documents. Or if he doesn't appear, you take action, whatever. That liberty has been given. So this other one also same order will go. Same summons was issued. Correct. Only wife. Okay. So order this is in 18, huh? This is in 18. And 17 will be, I mean, this applicants will be different. Same summons, same date and same date of appearance. The date of appearance. But that we'll find it out from here. Then we'll mention it there. Okay. Is it Dhar will require this or? Okay. Yes.
Whereby the directly India's cases about 19 packets of Gaja was found in respect of the hospital. Ultimately, he was arrested and why the statement was given. Maybe by pointing that something is going in such a jail. So ultimately, they found that lot of letters are going on for a jail. So ultimately, this jailer was arrested, which are. So there some time will be consumed in investigation. Ultimately, he has been so, if they want to carry more investigation, that will carry some more investigation. So you want this petition to be kept pending? 6 otherwise the case diary not received, right? Huh? 6th of March. Okay. Heard Mr. D. Das, the learned senior counsel, assisted by W.R. Medhi, the counsel appearing for the accused applicant. Also heard Mr. K.K. Parasa, the learned APP for the state. It is submitted that another matter arising out of the same FIR has already been fixed on 6th of March. So you write the number, so and so. March. Let the matter. But a case diary hasn't come, no? I mean, in this matter also, the case diary is not received. Just right, case diary. Case diary not received, and let the instant bail application also be listed on 6th along with that. You write that BA number so and so.
61 of supplementary list.
Okay, trial court record in the instant case has not been received. Though both the parties are represented by their respective counsel. Let the matter fixed on when it will come. Sometime on 12th of March. Let the matter fixed on 12th of March. Which one? Which one? This one already charge sheeted. Okay, okay. The registry to call for the charge sheet. The TCR it will come along with the TCR. Not required. It will be there.
63.
So where is he? He'll come. So we'll take it up after, I mean, at 2.
Maybe at number 60.
You have a good food in the canteen and come back later. Why at 2? This is motion over
Condition.
admission. Billing is over. Yeah. Already, I mean, when the order was passed. But he may not be knowing it. Okay, we'll take it up after.
Bail hearing item 37.
Billing আছে নেকি? Billing আছে? কিমান আছে? শেষ কৰি ক'লে ন? এডমিশ্যন আগত নমাৰিবা বিল এবি চব আগতে শেষ কৰি তাৰপিছত yes item number okay we'll pass over for time we'll take it.
Number 40.
She did not receive. Sir, she submitted, you go and appear. Heard Mr. SD, the Learned Counsel appearing for the accused applicant. Also heard Mr. KK Parasur, Learned APP for the state. This is an application you write. It is submitted by the Learned APP that charge sheet in the instant case has already filed. Wide charge sheet number? Is on? 20. In view of the aforesaid, the Learned Counsel appearing for the accused applicant submits that he should be allowed to approach the trial court for appropriate relief. In view of the aforesaid, the instant AB application is closed with the liberty to the accused applicant to approach the trial court for appropriate relief.
1.
You go whenever you went. No. Wait, there is no. I mean, if interim was there or what? Oh, give me the file. The interim is there, let him go, I mean, till the time we can protect him. Huh? Then in between, you write, the accused applicant was granted interim protection by 3/12/2025 by a coordinate bench of this court in view of the aforesaid. The interim or interim protection so granted shall continue till his appearance before the trial court. So he will get summons, then he will go before the trial court.
One.
CD not received. CD not received. CD not received. Let the matter be fixed on. You are appearing for somebody. Let the matter be listed. 13th of March. In the meantime, the interim order so passed earlier shall continue till the next date of listing. (49) on the prayer of the learned special counsel CBI, submit the learned counsel MSM Kumari, the learned counsel, learned special counsel CBI submits that she is going to file an she has filed an objection today itself, which is not on record. Therefore, she pays that the matter should be taken up on another date. Another date. Let the matter be fixed on 11th of March. 11th of March. In the meantime, the interim orders were passed earlier shall continue till the next date of listing.
Arrested by arrested on 9/2/2026. Then 14 days behind the bar. FIU PSC mercy 12. In the FIR, I was just by one officially. Maybe.
Motion matter.
Right. Ready. But nothing has been found in accused person. In this case, actually, this section doesn't fact. That's because any prima facie materials wasn't found. And in this case, you will not see it. I have stated your worksheets, paragraph 8, my petition.
Heard Mr. So-and-so, the learned counsel. Then it is an application under so-and-so. The case relates to an incident occurred at 12:30 PM on 7/2/2006, wherein several persons with a four-wheeler vehicle were found covering their faces at full stop. Allegation is that the accused applicants were. You were arrested when? On preparation, an allegation of preparation of committing dacoity in the area. The informant, after seeing the informant, the accused persons supposedly fled away. Call for the CD. Call for the CD and get the matter fixed on. 12-3. 12-3. No. 12-12. That is fine.
Item 63.
Was arrested on 18/10/2024. He is behind the bar for 1 year, 4 months and 5 days as a date. Out of 10 witnesses, my lord.
How many days?
1 year, 4 months and 5 days. Charge sheet was filed on 2/4/2025.
Yes, what is the stage now?
And charges were framed on 31/7/2025. There are total 10 listed witnesses. Till date, no witness has been examined. My lord.
Mm.
I first ground here is that section 48 notice is not there. Admitted is in section 48. What they have done rather is this. In their arrest memo, which your lordship may find at page number 58. They simply make a statement. The first para, last line. He has been duly apprised of his right, and his arrest has been intimated to his wife over force. As vague as this. No detail. Name, phone number, which be that as it may, my lord. Your lordship is already aware, my lord, that section 48 notice as held by the Honorable Apex Court in Vihan Kumar, my lord, that it has to be in writing. But I'll just place the relevant paragraph of due judgment, my lord, and thereafter, my lord. Will not kindly take the this Vihan Kumar, I'll just, because the lordship is aware that in Vihan Kumar, there were two judges, my lord, Justice Ha and Justice Ha. C. I'll indicate the para number.
Yes, para numbers.
Vihan Kumar, I'm relying on Justice Singh's, Justice N. Singh's
Which para? 51A.
internal page number 19.
Okay. And this Mihir sir?
Para 47.
47 and
Kesiri Reddy, I am relying on para 18H and 18G.
18-8.
H for house.
Okay.
18H and 18G, G for Ganga. And there is a division bench order that is criminal appeal number 234/2025. Here, I am relying on para 13, 14, 17. And the other bail application passed by your lordship, I am relying on para 10, 11, 12 and 13. They're all on 48 notice not being publicated. And there is one more order.
Yes, I got it. Mr. No, the delay is a different thing, but like what about that compliance of 48? 62. Yes. Paragraph 4 and 5. Yes. Hmm. Hmm. Wife of? Page? Hmm. 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 Mr. Biswas, division bench of this court has held the telephonic, this is sufficient. I am bound by that. Hmm.
Before that, my lord, the order which my learned friend is reliant, so I don't have a copy of that order. I'm trying to locate it from the mobile, my lord.
Hmm.
Because because my lord, what I understand is that, my lord, Bihan Kumar is passed by the division bench of the Supreme Court. In very clear terms, it is said.
No, Bihan Kumar, then Sridarsan came, and this court also in couple of matters held that prejudice approach. I mean, you'll have to see the facts and circumstances of the case, whether you have been prejudiced or not. Now, if there are materials suggesting that you have been intimated, and you have been explained about the detention, then that is kind of I mean effective communication of the grounds of arrest, and that complies with the mandates of section 48. So, and the case law that you have submitted of this code, that facts were different there. Facts were different there. What happened in the case is that no family member was intimated. Only WTO or WT message was sent to the jurisdictional police that is mandated in the BNSS, but no family member was intimated. There was no telephonic call to the wife. So in that circumstances, it was held that section 48 was not complied with. Mm.
That is, my lord, Bihan Kumar, para 3 of justice.
We are clear about Bihan Kumar.
For my sake,
No, we are clear about Bihan Kumar.
Because all Bihan Rakesh, one diversion case.
See, let me tell you one thing. Mihir Rakesh, in a recent judgment by Delhi High Court Division Bench, said it will be prospective. Not for, any arrest which has been made before passing of the Mihir Shah will not be applicable.
That judgment, my lord, all respect, my lord, that judgment neither say here nor say there.
No, it says that it clearly said it's for prospective.
I mean, it's my inability, maybe I'm not being able to communicate to that.
No, you are capable. Tell me.
In that judgment of this Delhi High Court.
You have it.
Yes. He has dealt with all the three distinguishing features which distinguishes that judgment of the division bench of the Delhi High Court is. In that judgment, a writ petition was filed challenging the very arrest. Number one. Number two, in that judgment, the division bench of the Delhi High Court dealt with. He has quoted all paragraphs of Rehan Kumar, Mihir Shah, Peshawar Reddy, and all these judgments which are in favor of the LT. Then suddenly, in para 70, without assigning any reason whatsoever, not even one line reason, that as to why it has to be prospective or retrospective, no reason whatsoever. He, on para 17, it says, arrest before Mihir Reddy will not. And the reliance placed in that judgment was on that prejudice test. Now, this prejudice test is negated by a division bench of our High Court Justice Michael. Yes, my lord, I can.
No, that I have gone through.
Yes. That prejudice test, which the division bench of the Delhi High Court is relying, is negated by our High Court.
No, but then another thing is that, Mr. Biswas, there is a case. Now, I don't have the case with me. I think that case has been decided by Justice Pardiwala and sitting with, I forgot the name. There, Supreme Court has held that if there are conflicts between two Supreme Court judgments, then it's not, it's not mandatory that you'll have to follow one or you do not need to follow the other one. It says that the facts and circumstances and like case which goes with in either of the two cases, that you can follow that. So that is a ratio laid down by a Supreme Court judgment. So if you take that ratio, then by taking that you will rely on the earlier judgment or you rely on the subsequent judgment, that principle goes.
That ratio
was settled by a constitutional bench of the Supreme Court, constitutional bench of the Supreme Court in national insurance case. That national insurance case was relied upon by our end. In that case, it says, if two
That
branches-
national insurance case was also relied upon by the Supreme Court by a division bench, and then they distinguished it.
in national is concerned, my lord, I cannot argue a case which our division bench has already decided. Because, my lord, the order passed by our division bench is binding on me, my lord, rather than the Delhi High Court division. Our division bench says that if two contradictory orders are passed by a bench of same strength, then the order passed in earlier point of time will prevail over the order passed in later point of time. That is what the constitutional bench in National Highway. Taking the ratio from that national insurance company, our division bench say that Darshan will not hold the field, that prejudice test will not come in view of their judgment. It is this Behad Kumar, Pravir Kutaista, and all those will follow. This will not come. There is no requirement of prejudice test. This is one. Second, my lord, our division bench in a similar factual, in that case, similar factual facts, where, my lord, because thereafter there was a long list of judgment which says that it is of the prosecution, if I say that it is being violated, it is the duties of the prosecution to prove compliance, not the duty of the accused. It is duty of the prosecution to prove compliance. Now, in that case, in that division bench case headed by Justice Michael Jonathan, in that case, it was a far better case than this. There was a 48 notice. That notice was even signed, but that notice was not taken. That created a dent or a doubt in the mind of the courts. That you have to, because at the end of the day, there is a case where the person is alleging violation of his fundamental right by the state. Now, once there is an allegation of violation of the most cherished right,
Then what do you have to say about this other division bench case?
that order, because
You can have a look. You have a copy? You give it to him.
because I'm sure that, my lord, that law, either it is a par incuriam judgment, because those laws were perhaps not placed before the court. Whether the court has dealt with all this previous judgment in this divisional judgment which they are relying, my lord, I do not.
All these cases have been discussed. All these cases that you have cited, discussed.
Yeah, but there is a quotation of this judgment, whether this has been discussed. Submission of the learned studying council in support, there are quotations that these judgments were being relied on. Reasons and decisions. My lord, there is a detail of your phone number, there is a detail of time and everything. And even the name is there about his address, which is due compliance of the provision of 50. Therefore, the ratio, my lord, go, my lord, here, my lord, go, my lord, with all respect, my lord, and with all humility, because perhaps this ratio is not in tandem with the ratios laid out by the Supreme Court in all those cases. Notwithstanding that, there are some specific details which, because the date, the time, the name, the phone number. And what about the present case at hand? No date, no time, no phone number, not even name, wife, simply. may I read one paragraph out of
From where?
this is my, just now, my colleague at the bar, the doctor has, given me, which is Farooq Ahmed, decided by the Honorable Apex Court, but the same question, whether Darshan Kumar and this, which one will prevail? It says that in the state of, similarly, in Kesari Upendra Reddy versus state of Andhra Pradesh and others, this court was pleased to hold in para 27 that the object underlining the provision that the grounds of arrest should be communicated has been explained by this court in Vihan Kumar Tupras. Therefore, the law laid down in Vihan Kumar versus state of Haryana has been approved and reiterated in the aforesaid decision.
Which decision?
That Darshan Kumar, my lord,
Hmm.
that Darshan Kumar was an aberration from the other line of judgment. This was the only, and thereafter, my lord, many high courts, including our high court and even the Supreme Court, have clearly said that it is Vihan Kumar which will prevail over Darshan Kumar. And this is precisely which has been held, my lord, I'm just giving the citation. I'll give the access online.
You have a copy? No. So, Mr. Bakayal, in this case, I mean, have you gone through this? Have you gone through the case diary? Then this is the trial court record, sorry. I mean, this section 48 notice is not there. Correct, it's not there. And only mention about telephonically intimating the wife. There is no, I mean, there is no specific acknowledgement from the side of the this thing also, arrested person also. On neither any phone number was given, neither name of the wife has been given. So it's very difficult from here to take a suggestion that it has been duly communicated. It's a pure case of failure on the part of the prosecution. No, that is a different thing, but like mandate has to be followed. He can come to bail after 1 month, after 2 months, after 5 days, after 6 days. That's a different thing. But see, that's a statutory provision, section 48. So if you do not give section 48 notice, it's gone. There is no, I mean, there is no here and there. See, I mean, yesterday only we heard a case, and in fact, I will be writing the assessment. There, what has happened, in that case, a written notice was given, but there was no acknowledgement. But it was stated that notice has been sent to the wife, who is based in Manipur. But at the same time, a document was prepared, proper detailed document, giving the wife's name, grounds of arrest, everything. There was a phone number given there. Then this accused person was allowed to call his wife over the phone. Then after calling, giving the details, there was an acknowledgement made by him saying that, like, I have spoken to my wife over the telephone and intimated about the grounds of arrest. And in that circumstances, it is an effective compliance because written notice was also given, and the learned counsel admitted later on that after 2 weeks or something, they have received it also. So there is a compliance there, but here there is no 48 notice at all. And you simply stated that, like, I mean, he has been telephonically intimated. So facts are different. Hmm. 58. Yes. Yes. That I have seen, he has been duly apprised of the grounds of arrest, and his arrest has been intimated to his wife over phone. It is an arrest memo. Arrest memo has to be signed by him. So arrest memo, have you explained, have you written here that, like, this has been explained to him, or this thing, I mean, that he has acknowledged that the phone was made? See, arrest memo is not for the purpose of section 48. 48 is a different mandatory provision altogether. It will not do. It will not do in this case. There is no notice at all. There was no message at all. Only simply you have written that telephone intimated. Which phone, I mean, what is the address of the wife? Where was she at that point of time? Nothing was there on the call. Nothing is there. So at least 48 notice should have been there. 48 notice is a mandatory notice that has to be given. And Supreme Court has clarified. And now there is no notice. Only thing is that telephonically intimated. And another case, I mean, Mr. Biswas probably, I don't know whether he should have brought that case also. There it has been specifically stated that WhatsApp, telephone, Supreme Court, telephone, WhatsApp, it will not be accepted as compliance of notice. No, WhatsApp, see, this court has also differentiated in certain cases. Now, what happens is that in another case, this court has already decided and rejected the ground. Where that in this case, what happened? WhatsApp notice was typically photographed. It was scanned. Then the given number, what the number which was given by the accused, it was sent immediately to her over the WhatsApp. The whole notice, contents of the notice. It is not a message saying that he has been arrested so and so. The whole notice was photographed and it was sent to. And in that case, there may be some compliances. So, but here, I mean, it's nothing is there. I mean, no mention of who has been, no telephone, nothing. It will be difficult, Mr. You cannot improve. Then that's what I mean. This court also needs to consider a lot many things. Now we'll have to see some if there is a mandatory provision and which has been reiterated by a Supreme Court, specifically writing in a paragraph. I mean, in the Vihan Kumar case, the honorable judge has specifically taken out that paragraph, and he has written that paragraph, and that hasn't been diluted by any of the courts. Those things are there, those things. The narcotics case also, I mean, covered. I mean, it says that like as CRPC has to be followed. No, in narcotics case also, this court has, see, this is not about narcotics case or this is something about rape or murder. See, it is the case of fundamental right. It comes from Article 22, 21 and 22(1). So Supreme Court specifically says that it's a question of liberty. It's not about like what, I mean, a crime you have committed or whatever. Those things too needs to be considered. Those things has to be considered, but priority is that if the mandate of the statute is not followed while arresting somebody, then it becomes difficult. That's what I'm saying. The minor discrepancy, minor lapses in procedural stuff, that's a different, those things are considered. Now, but like in this kind of cases where no message, I mean, no message, no written notice has been given, I mean, and telephonic conversation also, nothing has been recorded. I mean, simply making a statement, that becomes difficult. That becomes difficult. I'll pass the order.
Standing 37.
Charge sheet submitted, you go and appear there. Heard so and so, the learned counsel appearing for the accused applicant, also heard Mr. T.K. Das, the learned APP for the state. This is an application under so and so. Wide and order dated 29/2024. The accused applicant was granted interim protection in the instant case. Full stop. The learned APP submits that charge sheet in the instant case has already been filed by charge sheet number. What? 2024. In view of the aforesaid, the learned counsel appearing for the accused applicant submits that he should be allowed to appear before the learned trial court, and till that time he should be protected by this court. Full stop. It is directed. The instant application, this rebel application is disposed of with a direction that the accused applicant shall appear before the trial court on the trial court on receipt of the summons, and till date the interim protection given by this court by the order dated 29/2024 is extended. In terms of the aforesaid, the instant AB application is disposed of.
43.
CDS come. Hmm?
When I get this injury, I appeared before
Hmm.
I rejected my claim saying that such is responsible. And Mr. Data so not to make fix the matter next week. Let me get the
Okay. Heard Mr. G. Somo, the learned counsel appearing for the accused applicant. Also heard Mr. K.K. Das, the learned APV for the state. It is Mr. Somo, the learned counsel appearing for the accused applicant, submits that in terms of the interim protection dated 21/2026 given by a coordinate bench of this court, the accused applicant appeared before the IO, but he has been intimated. The charge sheet in the instant case has already been filed. In view of the aforesaid, let the matter be fixed on 6th of March. Still some March. Till then, the accused, till then, the interim order so passed earlier shall continue.
24.
Hmm.
This is a relief, right?
There is not at that. Notice on respondent number 2, the report of submission of notice on respondent number 2 is yet to be received. Let the matter be listed on when this is no, CD already received, I understand, but we'll wait till when. Okay, we'll fix it on 26th. CD so received to be retained. Let the matter is fixed on 26th. 26th we'll see. Then if nobody comes, then we'll have to appoint somebody.
55.
Yes.
Point regarding the harassment. Notice the FIR in the charge sheet, the name of the accused number 3, harassment is different. My father name is different. So I am not the person, but the police wrongly immediately in the charge sheet file this article. My lord, the father name is different in my lordship. But one file can agree in the narrative position with the state to be rejected. And recently, my first year, sent a summons in my home to appear as per also. 4th of April, my lord. Before I come to the merits, my lord, this is my first submission, my lord. My father name is the same. My father name is my lord, Danish Ali. Tashrik and in the upper father's name is Sheikh Shahbari.
You are the one who pointed out. He was not. Now what is to be done, Mr. Parasar? But charge sheet has been filed and he is not named. But he is saying police is coming. Someone has been also sued.
His name, here in the summer also, Yusuf, other name is Sheikh Sir. I am saying.
Different person. Sheikh sir.
Yes, brother, I'm not the person, but
The someone has been sent to his house.
I am not the person.
You don't take any coercive action, let him go. I mean, let. No, someone has been sent to his house. The police is coming to his house because the name is same.
I'm not completely. Completely corporate. Yes, yes.
Bail rejected earlier. You have pointed out that you are not the person.
Council concern, I have talked with him and I have said in the particular definitely is the husband by particular.
It was not reflected. Heard Mr. So-and-so, learned counsel appearing for the accused applicant, also heard Mr. K.K. Parasar, is an application under so-and-so. That an FIR was lost. On 4/11/2024, alleging that some miscreants were transporting cattle from Kanubari area, from Kaunbari area via Fulkatari through Tipkai River with the intent to smuggle cattle to Bangladesh by a engine boat. On receipt of the information, police team went to the spot, and you were not, I mean, there at the spot. And police arrested whom? Police arrested two persons, namely Bilal Hussain and Moinul Haq from the spot. Full stop. After the incident, the Gauripur, after the incident and after receipt of the FIR, Gauripur police station case number 355/2024 was registered under the aforementioned sections. Full stop. During investigation, the police charge sheet has been filed. No? When? After investigation, the police filed a charge sheet on by charge sheet number 70/2025. 70/2025. It is seen that the learned counsel appearing for the accused applicant submits that in the charge sheet, a name of the in the charge sheet, the name of accused applicant has been mentioned. However, you are Afiluddin Mondal, na? Yusuf Ali. His name has been mentioned as only Yusuf, na? Not Yusuf Ali. You see what's, huh? Charge sheet. He submits that though the name of one person, namely Yusuf, has been mentioned against the name of Yusuf, the father's name has been shown as late Sheikh Sab. Sheikh Sab. SHEIKHSAB. Sheikh Sab. He submits that the charge sheeted person, namely Yusuf, is not the same person. Yusuf is not Yusuf is not him. Yusuf is not him, and he is no way connected with any cattle smuggling or cattle transportation to Bangladesh. Full stop. In the FIR, your name is not there, na? Okay. He submits that in the FIR also, the name of one Yusuf appears, but name of one Yusuf Ali appears. However, the same is not him, as the father's name has been shown as Sheikh Saab, whereas the accused applicant's name is accused applicant's father's name is Danish Ali. But village is same one. Kaunbari, Goripur. There must be some mistake. I mean, you are the person actually. I mean, there is no doubt about this. You are the person. There is a mistake. So and so. He submits that since his name has appeared in the FIR as well as in the charge sheet, showing his father's name differently, differently, he cannot be the person actually the police and actually the investigating officer is looking for. Full stop. He submits that a summons has been issued to the accused, to him, wherein also though his name has been shown as Yusuf Ali, the father's name has been shown as Sheikh Saab, which is not his father. In view of the aforesaid, he submits that since the police is looking for him, he is apprehending arrest, and therefore at this stage he should be allowed to go on pre-arrest bail. The learned APP, on the other hand, submits that though the name of the father of the accused applicant has been shown as Sheikh Saab, it seems that the FIR named and charge sheet named person is the accused applicant only. Therefore, he submits that at this stage the bail should not be granted to him. There should be some kind of, Mr. Parasa, there should be some kind of inquiry in this. I mean, what is happening exactly? The police has mistakenly written his father's name differently. Okay, let him cooperate. I mean, since his name is different, taking into account the whole aspects of the matter. This court is of the considered view that at this stage, the accused applicant should be allowed to go on pre-arrest bail. Accordingly, it is directed that in the event of arrest of the accused applicant by the investigating authority in connection with Gauripur PS case number 355/2024, the accused applicant shall be released on bail on furnishing of a bail bond of rupees 30,000 with a security of like nature to the satisfaction of the arresting authority. It will be arresting authority only. But charge sheet has been filed against him. Then it will be. Before the which court is this? To the satisfaction of so and so, subject to the following conditions, that the accused applicant shall appear before the aforesaid SDGM, the court JMFC, within a period of 10 days. You go and appear before the court within a period of 10 days. Then you write 10 days, then you write that the accused applicant shall not try to temper or hamper, like that. In the aforesaid terms, the instant AB application is disposed of.
56.
Let him remain. Nothing much is there. Nothing. He'll cooperate. I mean, some small, I mean, heard Mr. S. Nawaz, the learned counsel for the accused applicant. Also heard Mr. Goswami, the learned APP for the state. Then this is an application you write. Then the FIR dated 2/12/2025 was lodged by one Chumbru Ede with allegation of dacoity in their establishment, during which copper wires were looted and the security guards were attacked. One of the guards, Sri Ratneswar Abha, was severely injured and admitted to the hospital in a serious condition. On receipt of the FIR, the police registered Gopalpara PS case number 221/2025. Wide and order dated 2/2/2026. A coordinate bench of this court has already granted interim protection to the accused applicant, and in terms of the aforesaid order, the accused applicant has appeared before the IO and got his statements recorded. Full stop. Taking into account the aforesaid fact, this court is of the considered opinion that the interim protection so granted by order dated 2/2/2026 should be made absolute. Accordingly, this AB application is disposed of by making the interim order dated 2/2/2026 absolute in the same terms and conditions as stated therein.
7.
Yes.
They were arrested and subsequently they were convicted.
Who? Manjul? Page 18. 18, yes, on the top. Manjul Islam and Asigul Islam, yes. Mm. Mm. Mm.
6, column 6.
Mm.
SK
description of the article seized matter. Second part matter.
Hmm.
Weight of the suspected to be heroin,
Hmm.
13.46.
Hmm.
This is the seized materials matter which is
So intermediate quantity
intermediate.
and weight of the suspect heroin 13.6. That altogether it goes to
With soap cases 39.20.
correct.
Without soap case matter 13.
Okay, without software 13.1416. Yes.
Serial number 7.
Hmm.
Details of circumstances under which articles are seized. The seized suspected to be heroin was stored in the rented house of Abdul Masjid, son of so-and-so, village so-and-so,
Hmm.
of so-and-so, rented by Shahidul Islam. What should I got it, madam?
Hmm.
Shahidul Islam of so-and-so. I am Shahidul Islam. Madam.
Hmm.
I gave my room to one Abdul Masjid, madam.
Hmm.
And in Abdul Masjid's room, madam, these two persons were apprehended with this manner heroin.
Abdul Majid's room, these two persons were apprehended.
Yes,
And you have given that place on rent.
yes.
And these two persons have already been granted bail. That Manjarul Islam and the so and so. So what remains in this case? Hmm. 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 Hmm.
The Caesar location is also
Hmm.
and they fled away.
Hmm.
So all of them were present at the point of time
Hmm.
because they cannot be arrested.
Hmm.
So the police has not written that they have been seized from their outfit.
Hmm.
Otherwise, FSL has not issued.
I have made a categorical statement, page 5, paragraph 4. Page 5, paragraph 4.
No, I mean, now the thing is that it's an intermediate quantity and main accused have been already granted bail. Then what remains? Hmm?
So it is a intermediate quantity. It will be decided that will be also there. Otherwise, FSL is fed.
Page 5, paragraph 4. Page categorical statement. Page 5, paragraph 4.
Hmm.
That the petitioner begs to state, suddenly police purely on suspicion visited the house of the petitioner in connection with the incident date. But as the petitioner were not at home, for which the police could not arrest them, but left message to the inmates of the house to send the petitioner to the police station, otherwise to face severe consequences. As such, in view of such direction, there is a serious apprehension in the mind of the petitioner that the event of the appearance before the IO, they might be arrested and put at their house.
And where is your statement that these two people have been given granted bail? When they have been granted bail?
On 2nd of, they were arrested on, 4/1/26, and they were granted bail on 2/2/26.
Okay, let him even. Heard Mr. N.J. Dutta, the learned counsel appearing for the accused applicant, also heard so and so. Reason application you write. Then you write, the prosecution case is that on receipt of certain secret information, police visited the the rented premises of the accused applicant, namely Sahidul Alam Ahmed, which was rented out to one Abdul Majid, comma, and Abdul Majid, full stop. It was alleged that during the raid, two accused persons, namely Sahidul Islam and Oyullah, it was alleged that during the raid, two other accused persons, namely Sahidul Islam and Oyullah. No, one second. Two accused persons, namely Sahidul Islam and Oyullah, managed to flee away from the place of occurrence, taking advantage of darkness. However, the police arrested the accused, two other co-accused persons, namely Manjul Islam and Kasikul. Page 15. Yes, Manjul Islam from the spot. Full stop. On receipt of the FIR, the police registered the police register the Bhatadrova police station case number 2/2026 under the aforementioned sections. Full stop. Full stop. The Mr. N.J. Datta, the learned counsel appealing for the accused applicant submits that the accused applicant is no way connected in the aforesaid incident or allegations as alleged in the FIR dated 3/1/2026 as the accused applicant has in fact rented out the house to one Abdul Majid, and he was unaware of any activities in his rented house. He further submits that as alleged in the FIR, he was not present in the house during the raid carried out by the police on that date. Full stop. He submits that in fact, since the police arrested two persons and there was a message left in the house saying, asking the accused applicant to come to the police station, being apprehensive of his arrest, he has approached this court for a pre-arrest bail. He further submits that the two accused persons, two aforesaid accused persons, namely Manjurul Islam and Asikul Islam, who have been arrested from the spot, have already been granted bail by the trial court, by the lower court, by the trial court. Trial court means it hasn't gone to trial as yet, right? By the Sessions Court POCSO. Sorry, Sessions Court NDPS. NDPS which court? Nagaon, na?
Additional session just number 2.
Additional session just number 2, Nagaon, on 2/2/2026. The learned counsel further submits that the alleged heroin seized was also of intermediate quantity in the instant case. In view of the aforesaid facts, he submits that the accused applicant should be allowed to go on pre-arrest bail. On the other hand, Mr. P.K. Das, the learned counsel, learned APP, Mr. K.K. Das, learned APP submits that the accused applicant was in fact present at the time of raid of the house, and he fled away when he saw police coming to the place. Full stop. Therefore, he opposes the bail application, taking into account the whole facts in entirety, and the fact of recovery of intermediate quantity, as well as that the two arrested persons from the house have already been granted bail. This court is of the considered view that at this stage, the accused applicant should be given the privilege of pre-arrest bail. Accordingly, it is directed that the accused applicant shall be released by the investigating officer in the event of his arrest on furnishing of a bail bond of rupees 50,000 with a security of like nature, subject to the following conditions. Conditions, you write: 1, that the accused applicant shall appear before the IO within a period of 10 days of passing of this order. Number 2, the accused applicant shall not in any way try to hamper or temper. Then number 3, you write: the accused applicant shall fully cooperate with the investigation and make himself available as and when called for. And in terms of the aforesaid directions, the instant AB application is disposed of. Applicants, two applicants are there. This Oinul or then here, both of you.
51 along with 31 in 1.
31 is bail hearing, then 1 is also bail hearing. Motion. So this person is inside jail for how many days? Huh? Motibor is 46 days. 42 days. Item, this is item number 31. Item number 1, how many days? Huh? The 61 days he's already
You should get that to
hmm?
kill the push button.
Hmm.
One comfort does was at 21 to 26, 33. And another is absolutely built by one of the parents, the heavy. Second one. Those families from the one.
Hmm.
That is clear.
So main accused were Motibor and Safikul Ali. Hmm? Who? Safikul. Hmm. Motibor is already 41 days. 46 days. 46 days. You are labor. Motibor and this person. Safikul? Safikul driver, Motibor, and who are the other persons?
Unexpected behavior, that by one Pankaj Da.
He was the driver, Pankaj Das. Pankaj Das was the driver. And what is the deep duty? Huh? Same vehicle, Pankaj Das and deep duty. These two brothers. And from this vehicle also cattle recovered. So they are escorting the vehicle.
There are other two cases are pending lordship. That is under 325, 154, another case is 141, 310 is also there. Okay, so what is happened lordship? If I go into the FIR lordship, it has shown that how they are arrested lordship.
They were trying to lift the vehicles. So it was seen in the TV news channel. The,
the police in pursuit of them lordship go by behind them and they try to keep two vehicles are there and when the police try to arrest them lordship they all of them went away. They fled away. Then after that it is arrested. And they are according to this they are the cow smugglers lordship and these two persons Mutipur Rama and this one lordship Arab and Mutipur they are the persons who took this cow. And these are the drivers and riders. And this motive also the person who was this.
so ultimately, I mean, these people are basically their drivers and all these things. The barricade was this thing. Hmm? Already they have spent 46 days. But I mean, I don't know how it is to be stopped, this. But what about the owners? But ultimately, whatever, I mean, some illegal works are being done by. Hmm. Heard Mr. from the learned counsel appearing for the accused applicant. Also heard Mr. So-and-so, the learned APP for the state. This is an application on the so-and-so. The brief facts of the case is that the informant SI of Baihata Sariali police station lodged an FIR before the Baihata Sariali police station on 22/12/2025, stating inter alia that the informant, along with his staff, conducted patrolling duty at Dumuni Choki bridge, intercepted a truck bearing registration number AS-25-CC-4819 loaded with 39 numbers of cattle, 34 numbers of cattle, in bracket 29 alive and 5 dead, was proceeding towards Barnihar, Meghalaya from Dhula side without valid documents. It was alleged that the said truck was escorted by one Scorpio bearing registration number AS01FX-5102. And after seeing police, both the vehicles tried to flee away from the spot. However, the police party managed to detain the truck at Duminichok Bridge, and the Scorpio managed to flee away. It was alleged that the truck was driven by one Moinuddin and Pankaj Das, and the Scorpio was driven by one Aftab Hussain and Babu is Pankaj Das, na? Babu alias Motibur Rahman. During the detention of the truck, it was alleged that a Scorpio vehicle tried to crash the police vehicle. First of on a search, the police recovered total 34 numbers of cattle in a very poor condition. First of on receipt of the FIR, the police registered the Baihata Charili PS case number 306/2025 under the aforementioned sections. Full stop. Charge sheet not filed, na? Till name. The police arrested the accused applicant on 8/8/1/2026, and for the last 46 days, the accused applicant is inside the judicial custody. The learned counsel appearing for the accused applicant submits that that the submits that the accused applicant is in fact a driver, and he's not connected he's not connected with smuggling of the vehicles, smuggling of the kettles, smuggling of the kettle. He submits that he was only driving the vehicle, and he doesn't own the kettle as well as the vehicle. He submits that since the vehicle has been given Jimma, since the vehicle has been given, vehicle as well as the cattle have been given Jimma, and another FIR named person that is that is huh? Safiqul Ali has already been granted bail by which court? Learned SDGM Rongia. Rongia, the accused applicant should be also allowed to go on at this stage, as further custodial detention of the accused applicant may not be required at this stage. Full stop. The learned APP, on the other hand, opposes the bail application, submitting that there are incriminating materials against the accused applicant of his involvement in the instant case. Full stop. This court has heard the submissions made by the respective counsel, and taking into account of the fact that the vehicle as well as cattle have already been given Jimma to the owners, and the accused applicant, being the driver, has already inside the jail for last 46 days. 46 days is of the opinion that the accused applicant should be should be granted bail at this stage. Accordingly, it is directed that the accused applicant shall be released on bail on furnishing of a bail bond of rupees 30,000 with a surety of like nature to the satisfaction of SDGM Rongia, subject to the following conditions: that the accused applicant shall cooperate with the investigation, fully cooperate with the investigation, and shall not try to tamper or hamper with the witness, with any witness involved in the instant case. In the aforesaid terms, the instant bail application is disposed of. Here also you write an application and write this heard so and so application, you write facts, you write FIR, that same, then you write a learned counsel appearing for the accused applicant submits that the accused applicants are these people are who? They are brothers. The accused applicants are both brothers, and they are the drivers of the Scorpio. And Pankaj Das is the driver of the Scorpio, whereas Pankaj Das is the driver of the Scorpio, wherein the accused applicant number 1 was also traveling full stop. He submits that the accused applicants are not the owners of the cattle, and also no way. Also, there is no involvement of them in the alleged cattle smuggling or transportation. The learned counsel submits that the accused applicant number 1 has how many days? Has already spent 61 days, whereas accused applicant number 2 has spent 32 days behind the bars. And therefore, he submits that further custodial detention of the accused applicants may not be required at this stage, full stop. Learned, Mr. K.K. Das, the learned APP submits that there are criminal antecedents of the accused applicant number two, and there are there are materials them against them um, against them prima facie, showing their involvement in this kind of activities. Therefore, he opposes the bail application at this stage. Full stop. The next parallel, this court, after hearing the submissions made by the counsel appearing for the respective parties, as well as taking into account the lengths of detention of both the accused persons, is of the considered opinion that the accused applicant should be allowed to go on bail at this stage. Accordingly, you write the other things same. The accused applicant should be allowed to go on bail. From the other order, you take it. And this is disposed of.
He's the owner of the catering.
He is the main person. Where is your certificate, veterinary certificate? Hmm? That cattle preservation prevention, that this is the one, Assam cattle preservation. Heard Mr. So-and-so, the learned counsel appearing for the accused applicant. Also heard Mr. Prasad. This is an application you write. Facts, I have already given FIR that to him, to take it from him. FIR so-and-so. The learned counsel appearing for the accused applicant submits that the accused applicant is the owner of the cattle, of the cattle that have been seized by the police. He submits that he has purchased those cattle for his personal use and have all the documents of such purchase. He further submits that the cattle have already been given Jimma. You have been given Jimma, na? Given Jimma by the appropriate court after verification of the documents, full stop. Full stop. In view of the aforesaid, he submits that the accused applicant, being the owner of the cattle, is apprehending arrest, and therefore the instant anticipatory bail application is filed. Full stop. Mr. K.K. Das, the learned APP, on the other hand, submits that there are sufficient incriminating materials against the accused applicant of his involvement in such kind of smuggling activities. First, there are antecedents against him. It is not there. He submits that there was no permit taken by the accused applicant while transporting the cattle, and the cattle were in fact transported in a very inhuman condition whereby 5 cattle have already had already died when the cattle were intercepted by the police. Therefore, he submits that at this stage that the accused applicant should not be granted any protection by this court. This court has heard the submission made by the counsel appearing for the respective parties and respective parties. Full stop. The Assam Cattle Preservation Rules 2022 specifically provides under Rule 6 that a person or agency or firm intending to transport or cause to be transported any animal, comma, specified in the schedule of the act, comma, for bona fide agricultural and animal husbandry purposes as mentioned under subsection 4 of section 7 of the act shall make an application to the competent authority as appointed by the state government for the purpose as per provision of subsection 8 of section 7 of the act in form C appended to these rules. It is also provided under the rule that interstate permit issued by the competent authority shall mention the designated entry and exit points as notified by the state government, and the cattle stock intended to be brought in stroke out based on issued permit shall only be done through the mentioned designated entry stroke exit points. Section 7 of the Assam Cattle Preservation Act 2021 also provides that for any kind of transportation of cattle, the competent authority no cattle shall be transported other than the provisions laid down in the act. In the instant case, no material has been brought before this court to show that any permit under Rule 6 of the aforesaid Assam Cattle Preservation Rules 2022 was taken by the owner of the cattle, that is the accused applicant. Full stop. Taking into the aforesaid fact of violation of the Assam Cattle Preservation Act and the rules made 2021 and the rules made thereunder, this court is of the considered opinion that the accused applicant should not be granted any relief at this stage by way of any protection under pre-arrest bail. Full stop. In view of the aforesaid, the instant AV application is rejected.
Item 60, admission.
So we will issue notice, I mean, there, I mean. But yes, your mistake you have committed, now you suffer. The criminal appeal 79, you write, 79, you write, heard Mr. A.K. A. Ahmed, the learned counsel appearing for the accused appellant. They are not right, accused for the appellant. Also heard Mr. Goswami, the learned APP for the state. Now this is an application, this is an appeal under section 415 in bracket 2 of BNSS, assailing the judgment dated 30/1/2026 passed by the session judge Kamrup Amingao in sessions case number 116/2017, convicting the accused appellant under section 307 of IPC and sentencing him to undergo rigorous imprisonment for 3 years. 3 years. While 3 years full stop period, 3 years. Admit the appeal. Admit the appeal. You have already sub copy now. I mean, there is no requirement of notice. So notice is, I mean, you have already appearing. So admit the appeal. Returnable within 3 weeks or 4 weeks usually. Returnable in 4 weeks. Admit the appeal. Admit the appeal. Let the matter be listed after 4 weeks. Then in IA you write the connecting IA has been filed by the accused applicant for accused applicant under section 430 of the code of 430 of BNSS for suspension of sentence and to release the applicant on bail during the pendency of the appeal. The accused applicant was as convicted by the judgment dated 30/1/2026 passed by the learned session judge. You write all this, that I have given written there, so and so convicted and so and so. The learned counsel appearing for the accused applicant submits that though he has a right to go on appeal at the time of conviction only, why you have the, I mean, why you have, I mean, then they write that the accused applicant failed to file any application before the trial court while passing the conviction order, and thereby he has And thereby he has been sent to jail on the very same date, no? He has been jailed on very same date by the learned session judge Kamrup Amingao. Full stop. He submits that since the conviction is only for 3 years and there are sufficient materials, uh, materials, uh, materials, mm, mm, materials, sufficient materials for him to argue a case of release in the instant case. Therefore, at this stage, during the pendency of the pendency of the connected criminal appeal, he should be allowed to go on bail by suspending the suspending the judgment and order and and sentence passed in 30 passed in the order passed by the learned session judge Kamrup on 31/2026. Full stop. You have anything to say? This court has, after perusing the materials as well as after hearing the submission made by the counsel appearing for respective parties, is parties is of the considered view that the accused applicant should be that the accused applicant should be allowed to go on bail at this stage by suspending the impugned judgment dated 31/2026. A separate order of sentence or what? What? Wait, when? Judgment 31/2026 and sentence dated 3/2/2026. Full stop. Accordingly, it is directed that the accused applicant shall be released on bail on furnishing of bail bond of rupees 30,000 with a security of like nature to the satisfaction of the learned session judge Kamrup Amingao. Kamrup Amingao. Full stop. Full stop. Accordingly, the impugned judgment dated 31/2026 and the sentence dated 2/3/2026 is suspended till suspended during the pendency of the connected appeal. That will do. In the aforesaid terms, this is disposed of. In the aforesaid terms, the instant IA is disposed of.
52.
Current heading at one. So we may be allowed to take steps to different.
Substitute how?
During that time of financial affairs, he was in Gauhati.
He is who? His informant is father. Is it a POXO case? Is it what?
But
You know why you are making? Acha, 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 acha.
we were not perhaps
You have come for washing.
claims not yet noted perhaps.
I mean, yeah, you have given the address of Jurhar. And nobody is staying there, Jurhar. Huh? What is to be done, Mr. Goswami? He can take substitute or what? Hmm? But he's not staying there. Jurisdictional police station, how it will be? Paper publication? Yeah, I mean, see, paper publication becomes defamatory. So it has to, you'll have to be cautious about giving that also. Once it is published in paper, then but you have not taken any fresh steps. You have been directed to take fresh steps. No, you have not taken fresh steps. Address was this only, na? You take a step. I mean, you take a step. But you'll have to at least take the steps, na? You take a steps. A direction was given to take steps. If you take a, you post it, speed post, let it come back. Then court will see what is to be done. Heard Mr. So and so, and write both names, sir. Office note dated 22/2026 reveals that no fresh steps for issuance of notice upon respondent on October 2 was taken by the counsel appearing for the petitioner. It is directed that fresh steps of notice should be taken by the counsel appearing for the petitioner within a period of 3 days. A wide speed post with AD. Speed post with the AD. Let the matter be fixed after 2 weeks.
53.
Criminal appeal. Hmm? Sorry? 317 days. Is statutory appeal. What is? We allow this? Huh? Then we'll dispose of this. Then we'll keep it. Once it is numbered only. Heard Mr. So and so the learned. I am in. Heard Mr. So and so the learned counsel appearing for the accused applicant. Also heard Mr. Goswami, learned APP for the state. This is an application filed under Section 5 of the Limitation Act 1963 for condoning the delay of 317 days in preferring the connected criminal appeal. Full stop. Being satisfied with the explanation given for delay. Delay in paragraph 3, 4, 5. No, but limitation, what limitation notice? Will it be required? That's why I asked you. No, I mean, okay, we'll issue notice then. Application under so and so. The limitation act so and so. Issue notice on respondent number 2 through the registry as per the prevailing notification issued by the Gauhati High Court. Notice to respondent number 1 is dispensed with as Mr. Goswami Laran APP puts in APS enters his appearance. Then you write list the matter. List the matter after 3 weeks, 4 weeks, after 4 weeks. Then you criminal appeal, you write nothing to be, no order to be passed. So we'll issue notice on this. Hmm? Correct, I mean, we'll have to issue a notice on this. Heard so and so. The learned counsel. This is only for limitation, right? The IA is for limitation. Yeah. Hmm. Okay, heard by so and so, the learned counsel appearing for the accused applicant. Also so and so, Mr. Goswami, is in application under section 5 of the limitation of 1963 for condonation of 53 days delay in filing the accompanying criminal division petition. Let notice be issued on respondent number, only one respondent, right? Let notice be issued on respondent by way of speed post with AD. Steps for notice to be taken within a period of 3 days. Let the matter be listed after 3 weeks. No, 3 weeks, I mean, 3 weeks, no, I mean, usually 4 weeks, but not before 3 weeks. Notice has to go, you'll have to take step, they'll have to receive it. It will take a little bit of time. Hmm. 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 Yeah, anyways, I mean, 3 weeks to minimum that it will be taken. Before that, it will not be served. Otherwise, you listing also, it will waste of time. Nothing will happen because
55.
okay, Mr. Conico, the learned counsel would accuse applicant also heard Mr. So and so is an application of under section 5 of limitation and 1963 ready to rule 2 in bracket 2 of chapter 5A of Guwahati High Court rules for condemnation for condoning delay of 54 days in 55 days in filing the connected criminal division petition. Let notice be issued on respondent number 2. Respondent number 2, wide speed by way of speed post with AD. Steps to be taken within 3 days of passing this order. Let the matter be listed after 3 weeks.